Yes. So good morning, everyone, and welcome to yet another version of the yet another version of SMS. So as you can see, SMS is all about meditating because we are just thinking what is there, and we are also going deep into it. Many a times, I'm also surprised to feel that think, Arey, for 7, 8 years we are reading this particular section, and then it's still I'm getting a different vibe altogether or a different context in that particular section. So that's the beauty of SMS. And I'm also happy to place on record that some of the departmental officers, they have also got benefited through our SMS. And one of the officers who is presently in Kolkata, sir, had actually shared that according to him, this is one of the deepest discussion that can happen. And sir feels that it is only because people are given free flow, because there is no structure in the SMS. कि ऐसा करना पड़ेगा, ऐसा नहीं करना पड़ेगा. So I think that also helps. And I think this was never possible without your constant support as a speaker, as a volunteer, as a volunteering as a speaker, and also volunteering to participate by giving your thoughts and views. So just because we had some requests from different group members across, we all four of us got different requests from different group members for tribunal discussions. So this month we have dedicated mainly to the GST Appellate Tribunal, just so that we can appreciate and understand that maybe tribunal is in the formation, but we also need to get prepared in the form of, in the terms of preparing the appeal applications. So what is to be taken care of, what is not to be taken care of, what is to be done, how the cost title will appear, whether there is any difference from the earlier regime of the stat VAT, or whether there is a marked departure. What are the things that we need to keep in mind? So all this we are going to come to know in the next 3 to 4 sessions. So today we'll be discussing again about some of the basic rules that have been there, some of the important things myself and Arpit will be sharing, and of course with your inputs and all. Then next week we are discussing on the GIDC judgment, the Gujarat Industrial Development Corporation judgment, which is very important in terms of whether tax is leviable on the transfer of the lease. Okay, sorry, a transfer or assignment of the lease. So that is there. And again on the 14th we are going to discuss about some of the pointers on specific pointers on the tribunal, where RPG and another speaker, they'll both take us through the pointers. And then on 21st of June, finally, we'll have a panel discussion wherein we are trying to have on board some of the advocates and chartered accountants who are regularly appearing before the tribunal, so that we get a flavor of what the field actually looks like. So with this background, I'll just see one. Arpit have you joined? I think, yeah. Okay. So I'll start. 1 second. So this is a presentation that I had made. I'm not able to do full slide. Yeah. Okay, so I would not get into all this. I think this is all known to us. This is just for another presentation that we had. So I'll quickly go to the tribunal part of it. Yeah. So here, as in the last date, we already discussed about this part of certified copy and the interlocutory application. These things we have discussed. We are also discussed about authorized representative, and we had a lot of discussion on this about who is authorized representative, what is a certified copy, what would be the meaning of certified copy, where the difference would lie. We already discussed about this. Then now coming to the powers and functions of the GSTAT, which is, I think, very important, because here the what has been discussed is in detail the formation, the format of the entire appeal that has to be drafted. That is also given in the rule. So just give me a moment. I'll have to switch between both of them. Yeah, just does anybody have the rules in handy? Like I think.
I have. Shall I share, Arup sir?
Yeah. If you can share, yes. Someone,
Yeah.
some from a download, it's not appearing actually. Someone, if you can share, ma'am.
I've shared you, sir, through WhatsApp.
Okay, thank you.
Page 32, I think.
Yeah, it's some issue with my network. Yes, so I'll just share. Yeah, is it appearing now? Anupama ma'am, I hope it's appearing.
Not yet, sir. I'm not able to see.
Yes,
Now
sir.
it is appearing,
Now
sir.
it is appearing.
Yeah.
Now it is
Yes.
appearing, sir. Yeah.
Yes. Okay, so we'll start from these powers and functions. So first thing is that here about the one interesting thing is that what we had actually contended for so long, even some writs were filed that whenever the last day is a working day, sorry, is a holiday, so that day, like in case of Sestat and all also. So if the last date is a holiday, then there should be, the last date should be shifted to the next working day and all this thing because we cannot file. Or in case of say Calcutta, like we have a Durga Puja, which is going on for maybe 5 to 7 days, and it's a nominated holiday. Like state government has a holiday for around 10 days. So during those days, if my last date falls in between the Durga Pujas, whether I can get a leave or not. So because of this, there are a lot of litigation. So in the GST Appellate Tribunal, this is something that has been firstly resolved. I think this is from which the set period is to be recorded shall be excluded. So that is again one interesting thing that they have clearly said, which is there in the General Clauses Act, that Section 9 says that whenever you're counting the day, the particular day from which the thing has to be recorded, that day had to be excluded. So that is the first clarity that we are getting. And the second thing is that the last day expires on a day when the office of the tribunal is closed. That day and any succeeding day or days on which the appellate tribunal remains closed shall also be excluded. So here there are two things. One is about the exclusion. Secondly, what is very important is that when the appellate tribunal is closed, so it may so happen that the state government may be closed for various reasons. Maybe the state tax is also closed. But if the appellate tribunal is functioning on that day, then we have to, that would be treated as the last work, that would be treated as the due date. But in case the appellate tribunal is not working due to whatever reason because of a holiday or is closed, then the next working day would be the due date that will be treated for this particular purpose. Unlike now, when we try to, whenever there is a last date is a due date, last due date is a holiday. So what we try to do, we file the appeal just before that day so that we are in compliance with the law. So I think this clarity is brought. And not only that, they have said that when days on which the appellate tribunal, so if it's succeedingly going on, like for 4 or 5 days, then even those days will be excluded and only the next working day would be treated to be the due date. So any views on this or any feedback that the members they have faced any challenges or how this would actually help us?
Rudy,
RPG, welcome. Yes.
welcome, Rudy. Rule 3 says
Um,
where a period is prescribed by the act or the rules
yes.
or
Yes.
these rules or
Yes.
under any the other law or
Huh.
is fixed by the appellate tribunal. So fixed by the appellate tribunal, they
Yes.
are very well entitled to change the counting and what they have to do. But how they can go beyond the
Yes.
period being prescribed by the act or any other law? Now, this any other law is only appearing for the filing of the appeal or it is for all the time limits.
No, if you have to read it together once again, where a period is prescribed by the Act, so that is okay. It's a filing of the appeal that is there. or the
No,
rules. Okay, that is
first,
also there.
where a period is prescribed by the Act, then the rules go beyond the prescription of the Act, wherein it says that the last day shall not be excluded where the tribunal is closed or anything is as a public holiday. Can the rules go beyond the Act?
No, since these are separate GST Act rules,
So why
and
they have,
they are being
so why they have then a period prescribed by the Act?
no,
If
that's what
the
they're saying. That when the Act is prescribing a particular day,
uh,
if that day falls on a holiday, then what is to be done? Or if because see, why I think why this clarity is being brought is that this is already litigated, as we saw in the Madras High Court or Jharkhand High Court judgment, for one day, that 30th November, 30th and 29th November matter of that issuing is of sure cause notice, whether 30th November should be excluded or not. For that, people went to the court. So
no,
don't
Arunji,
you think that?
what I'm trying to say that if supposedly,
Hmm.
first of all, what is the scope of period prescribed by Act? Because if we read through till the end, it is only
Yes,
speaking about appellate tribunal remaining closed and excluded. So
yes.
whether this provision rule 3 is only applicable for filing and not for any other matter.
No, it would be also for other matters, not like say affidavit in service you have to serve. So I have to serve an affidavit of service, and or I have to file an affidavit in opposition. Okay, I have to furnish
Yes.
some evidence. So the date is say 7th of the June, and 7th of June happens to be a holiday for the tribunal. ठीक है, पहले like 6th June was supposed to be Eid. Now 7th June is supposed to be Eid, and so 7th June is declared to be a holiday. So there I get one more day, the succeeding. So now 7th June is a holiday, 8th June is also say a Saturday, 9th June is a Sunday. So 10th June I can file it. So I think it will also
So,
include all the other activities also.
but this is not a some procedure which has been for which a period has been prescribed by the Act. So they can very well determine it. But for something which has been prescribed by the Act to include the last day also and not
Hmm.
specifically exclude the closure of the tribunal, how can the rules go beyond the statute? Secondly,
Acha.
it further says or
Okay, you're
under
saying since
any other law.
you're saying since 112 is saying me telling me
Yes.
about 3 months. So how can they say 3 months and one day and all?
Yes. And secondly, how can they extend for anything which has been prescribed under any other law? Because in that case, if the something is to be done in any other law and a period has been
Hmm.
prescribed to include the last day also and to include the date of service, how can they go beyond by these rules? So somewhere down the line,
Acha,
by those rules, they are creating a notwithstanding anything contained anywhere in the statute or any other law for the time being in force.
yes. And that we'll find in many places. That we are
So
finding in many places
how
where they
can they
have gone
go
beyond the law.
beyond? So how can they go beyond the see whatever is within their purview, they can very well decide the time limit. But for something which is
Yes.
prescribed in the CGST Act or something which is required to be done under any other act, for which the time limit is there in
Yes.
any other act.
No,
So let us for a
RPG,
minute, sir, once again I
RPG,
want to say something.
yeah.
Sir, if
So
we
ma'am, just one.
assume that,
RPG,
Yes,
so
sir.
ma'am, just 1 minute. I will just judge. So I was saying कि अगर इसमें any other law would be General Clauses Act, no. So we are already
Yeah,
fighting
but
on
they
that
have not,
particular aspect.
but they have not
General Clauses
restricted
Act
to
is allowing
general
me
law.
to do this. No, they have not restricted. They've got said about all other law. So ma'am, yes.
yeah, I mean, if for a moment we assume that this clause were not there, then the
Yes.
GST Act is silent with respect to that holiday that falls on the last day. So in that case, we have to go to the Limitation Act 1963, where it says that that the holiday will be excluded for the purpose of calculating limitation. So should we not lead it together, this with the Limitation Act?
But till now, ma'am, we are arguing, no, that the department is arguing, no, that Limitation Act will not be applicable because it's all electronic filing. So for electronic filing, how is the holiday going to be impacted? You can also file on a holiday. So all those arguments are taken in the court. So RPG is saying that when there is a limitation binded by the act, so how is it going beyond that? So that is what RPG is trying to say.
And Arubda, I think there is one
Yes,
judgment also.
Mahesh.
They
Yeah.
have said that then when the Parent Act itself has a time limit, you cannot resort to the General Clauses Act.
Yes. So that is also there. So that's why I said there are contradictory judgments of the different high courts wherein people had to spend money for one day. You know, whether that should be excluded or not
So
excluded.
by this rule, probably the tribunal is acting as a high court. They are extending the time limit which is given in the act itself.
Yes. Yes. Because this is what I
Aruji, by
yes.
this extension, not only the assessee but the department would also be getting the
Yes, both
extended
will
time.
get
So we have
benefited.
to see both ways.
Yes, yes, yes. No, that will be the both ways. Whatever benefits will be given, it will be given both ways. No, but RPG, I wanted to have another discussion on this is that prescribed by the act or the rules or these rules, so we can understand. But what about any other law? Fixed by the appellate tribunal is also okay whenever you ask to do something. But what is the purpose of bringing under any other law? So if any of the members can share their views on this. And RPG also, but the
No, I am still to figure out the why they have provided any other law.
yes, मतलब एक तो general clauses act हो सकता है.
Sir, may I, sir?
Yes, sir, please, sir. Yes, we want you, sir.
So first thing, any other law is the functioning of the tribunal would be earlier in the act. It was written as the civil procedures court. All the powers are like that. Now it will be the equivalent BNS laws which are
Right.
there. So
Yes.
those laws will be applicable in any other act. Or there could be some other laws also.
Do
Second thing, my view is
Yeah.
that
we-
this
Everyone is
rule
prescribed.
is not extending the time as given in the act. It is just giving a mechanism how to compute that time. So it is just saying that where a period is prescribed, in computing the time, this would be done. So they are just clarifying how to compute the time. They are not extending the time that
Yeah,
this will
so-
be not the last date, that will be done. So it is just a
Right.
procedural aspect which they are clarifying, and they can do that. They are not going
this-
beyond
this-
that. They will not say, yes, sir.
No, I think Gurjit, sir, what I have shared, even this I feel is that this is the culmination of all the litigation that has happened in the earlier regime during Sestat and all, even in the VAT, that, you know, whether this day should be excluded, not excluded, you know, whether what happens if a holiday is there. Okay, so I think they have brought in that particular clarity so that this litigation is at least resolved.
Aruji,
Because
Aruji,
again-
let's take it in another
Huh.
manner. Department is given a time by the tribunal to file an affidavit within 7 days.
Right.
Supposedly, and that time for submission of the affidavit is there in the CPC. Example, I
Yeah.
am taking a hypothetical example. I am not.
Yeah, ekdam.
Yes. The time limit for furnishing that affidavit to the department is given 7 days in CPC, and in person of the relevant provision CPC that affidavit. Now, by virtue
Okay.
of this, the time limit of 7th day is falling on the holiday, and it goes beyond
Yeah.
7th day and falls on the 10th day. So, as a
Right,
assessee, I would be well within my power to argue that how can Rule 3 of the tribunal can go beyond the relevant statute, because rule cannot override the statute. And if something is to be done within a time limit, for which the last day is to be included irrespective of the fact that it is a holiday or not, because I am also
Mhm.
being asked to file the return on 20th, when 20th is
Mm.
a holiday. So how can the
Right.
rules go beyond and given an extended time limit to the department and challenge this rule?
Right.
Sir, I would like to add a small thing.
Please, sir, please.
Sir, I think we need to differentiate between period and date. Like here it is mentioned where a period, it's not talking about a date. कि भाई 20
Okay.
तारीख को आपको ये करना है. If it is 20th, it is 20th. But if it says 7 days, 30 days, 1 month, 3 months, so in that case, Act has prescribed a period कि भाई 7 दिन में आपको ये काम करना है. Now वो 7 दिन कैसे calculate करना है? Like earlier sir also highlighted कि it is the computation of days, computation of the
Mhm.
period. So 7 दिन कैसे, कौन से 7 दिन कवर करना है या 7 दिन कैसे calculate करना है? For that, I guess this rule is here. So
Himanshu ji, that is the first part. That is about the
Correct.
first leg. The day from which the said period is to be reckoned shall be expressed. So RPG is saying about the second part. That when the law is mandating that you have to file the appeal within 90 days. Okay.
Exactly.
And the 90th
So-
day falls. So in the 90 day falls on the holiday. So why should
yeah, so
department?
I'm talking about that only कि 90 days law ने लिखा है.
हाँ,
But वो
हाँ.
90 days को कैलकुलेट कैसे करना, आई थिंक वही शायद
अच्छा
डिफरेंस ऑफ ओपिनियन वही है
हाँ हाँ
कि
हाँ
90 डेज, सपोज 90 डेज में से लास्ट के 45 दिन हॉलीडे, जब कोई चीज फंक्शन कर ही नहीं रही है, तो हाउ डू यू कैलकुलेट दैट? पहले वर्किंग डे और
राइट
नॉर्मल डेज का भी एक डिफरेंस रहता था कि 7 वर्किंग डेज एंड
हाँ
7
हाँ
डेज.
हाँ
So
राइट
I think that will also create a problem here because 90 days is very clear enough कि 90 days मतलब 90 days होता है, but I think थोड़ा सा ये लीवे इसमें ले रहे हैं.
Okay. And RPG, one thing to note is that the word is and they have used. The day from which the said period is to be reckoned shall be excluded. And if the last day expires on a day when the office of the appellate tribunal is closed. That day
And
and any succeeding day or day. So
this rule
I
3
think the
is going
period, जो
beyond
अभी
the
हिमांशु जी
this rule 3
yes.
is going
So
beyond the interpretation of various timelines, how it is to be calculated, and going beyond the specific word which has been used. Supposedly, it is within 90 days. So whether
yes.
within 90 days last date would be included or not, this is going beyond that interpretation of within. And in my opinion, till the extent it is favoring me, I will go by this. But once it
Yes.
goes against me and gives an extended timeline, there is a point wherein I can challenge this.
नहीं वो तो है. But I think RPG, one thing is that since this is a beneficial kind of thing that has been ruled, that has been
Sir, but
introduced,
this
which is
benefit is also being extended to department.
by the department. Yes, yes, yes. वो तो होगा. It will be both.
So I
Totally
would
वो
be
both है.
taking an options choice to the extent it is
Hmm.
benefiting me. I will go by this, but once it benefits the department, I would challenge it. And somewhere down the line, even though I'm not
हाँ
against it, but we need to understand that why this broad provision has been put in, wherein they are extending the timeline and how they are assuming the power. See, we might not be knowing the specific reason. So there might be some gap in understanding with us also that how they
yes.
can go beyond, because to the extent I have read the constitution with regarding GSTAT, regarding the appeal tribunals, they are having their powers in the constitution to formulate their own rules.
Yes, separate.
So
Yes,
can
yes.
that
That power is
rule,
there.
then can that rule making power prescribed in the constitution can override the other statute or the statute in which the appeal is being filed? This is one thing which we also need to see. I
So the
am taking
power
both
is
sides, and
given within the Act also. The Section 111 gives the tribunal the powers to make
Frame
its
rules.
own
Yes.
procedures. So now the challenge is whether it is part of the procedures, this computation period, whether it is part of the procedures or is it not. Yeah, but there is a
Yes.
scope like RPG is saying. But since the Act also, GST Act Section 111 says that for certain they have the powers like as per the CPC, but they are not bound to follow those procedures. They can have their own procedures. So whether this calculating the day is part of the procedures or not, so that will be the arguable point. In the Constitution also it is there. It is specifically given in the Act also.
Yes. And
food
while
for
on
thought,
this
Arup ji.
RPG,
Food
हाँ
for
हाँ
thought, Arup ji. क्योंकि 8 साल हो गए GST
yes,
को, we
yes.
are still deliberating. So this is a food for thought for the members.
No, no, yes, yes, yes. Because see,
Yes.
I was while preparing this presentation, I was just going through about formation of the tribunals basically. What was the purpose? Why did you with all these tribunals for faster litigation settlement and all? So there I saw that the powers were actually given to them to set up their own framework, own rules. So maybe what you have shared, that would also be a point that they have been given these rules so that they can work independently just to meet up the kind of due process of law. So just because that's why I wanted to share your attention to this particular rule also, Rule 14, which is there now. See, here also a separate power has been given to them, though this is on a limited jurisdiction. Yeah, this one, Rule 14, power to extend time. The appellate tribunal may extend the time appointed by these rules or fixed by any order for doing any act or taking any proceeding upon such terms, if any, as the justice of the case may require. And any extension may be ordered, although the application for the same is not made until the expiration of the time appointed or allowed. So here also there was an argument where we were having another discussion with another group. So the argument is that in this case, say department was supposed to do a particular act, file a affidavit in of opposition, and they have not filed the affidavit in opposition. So tribunal goes to ahead and then give the extension. Ki, "Theek hai, you have not filed it, but still we feel in the interest of justice, we give you 1 month time." So RPG, your views first, and then we'll take the views of the house on this.
And what I said, the appellator may extend the time appointed by these rules. So
Yes.
Rule 14 is somewhere dealing with the situation which are within their purview,
Right.
and they are very well entitled to deal with them.
Right. No,
But
I'm
Rule
I'm
3
mainly
is
concerned with the last line.
application
Although
same is
the
not made
until the expiration of the
within.
time appointed or allowed.
So in this case, again, this is something within the rules. Secondly, on this point, I can always make an application, sir, since I am an aggrieved party. So
Yes.
an opportunity of being heard should be given to me before extending the time limit, because this is going against my interest.
Yes.
Because even if it is not there, still I am entitled to make an application, because in previous VAT, Rajasthan Sales Tax Act, there was a provision wherein the commissioner may extend the time limit for doing something.
Right.
And although no specific provision was there for making an application and hearing the assessee,
Okay.
being agreed by extension of that time limit. So Rajasthan High Court in 1998 in that judgment said that if he is aggrieved by extension of that time limit, although it is not written, the department is bound to give an application or an opportunity to the assessee to argue his case. So even if it is not there, in my opinion, it should be deemed to have been included. Secondly, Rule 14 is doing something which is within their power, except for making
Okay.
extension without making an application
No,
to the.
yeah.
But Rule 3 is going beyond for the act and any other act.
Okay. So
So
any
again,
other views? Yeah.
so if this is a procedure prescribed, then I think if a section allows that a procedure may be prescribed by rules,
Mm.
and these are a part of procedure,
Yes.
like sir said, then I think it is fine. But again, in Rule 14, if they are allowing tribunal without the power given by the section, then same question arises as in Rule 3, that how can a rule allow, and if it is the power given
Mm.
by section ki bhai haan, appellate tribunal can extend time as required or as per their convenience. But how can rule allow if it is not allowed in section?
Arupta, sir.
Yes, sir.
Sir, if we can see on the screen the Rule 14, in
Yes.
my view, the fulcrum of this rule is the phrase "as the justice may require it," sir. As the justice of the case may require.
Yes.
So that is the fulcrum. So if, say, like Pitsa was saying, that if I am aggrieved by that extension of time, this will be the fulcrum on which I'll have to base the case, that granting that extension to the other party harms the justice which is being sought by me. The powers to the tribunal to frame their procedures are also given. It is specifically mentioned in section 111 that they'll have to adhere to the principles of natural justice and all that. So that is the primary, say, the foundation on which all these things are based upon. So they will have to be challenged if there's a challenge to this, with that
Okay.
also in mind. Yes. Sorry. There was a call. Yes. Okay. So any other views on this?
Okay. So RPG, should we move forward or?
Yes.
Yeah, I think we should go. So now, I think we should, before going to the power of the registrar, also this is an interesting thing here which we see in Rule 12, that any urgent matter filed before 12 noon shall be listed before the appellate tribunal on the following working day. If it is complete in all respects as provided in these rules, an exceptional cases if it may be received by 12 noon, after 12 noon, but before 3 p.m. for listing on the following day. So maybe we can see a time date when matters are being filed today and the listing is coming on the next day in the appellate tribunal. KRPG, I think this is something which rarely happens, right?
Yes, it is. But with the specific permission of the appellate tribunal or president. So what is the scope? What would be the scope of the approving authority in case of appellate tribunal? Whether a single member, both members who have to hear, a registrar
Yes.
of the tribunal, because appellate tribunal or president, they could have mentioned the vice president of the state tribunal or the president of the tribunal, but of the appellate tribunal.
I don't know about this. I think the process has been laid down later on about listing and urgent listing and how to, we have to see the later on. But yeah, one thing is that
But
why the word president has been used, that is also another mystery. Because president is not going to be
yes,
here in the regional benches.
Also,
yes,
sir,
he
how
is
do
not
you
going to
define
hear
urgent?
the
And
Yes.
what would be an urgent matter? No,
Yeah,
sir.
how do you
What would
define
be-
Yes,
it?
that's what Himanshu was sharing, right? So what is an urgent matter? That again, how the urgency will be sought, like whether
If
it is a bank
department
attach
feels it's urgent, it's urgent. If not, it's not.
or whether a bank attachment matter, a interception matter, where the goods are intercepted, the vehicle is impounded, and we need to release the vehicle at the earliest. So whether that could be urgent matters.
I'm
See,
looking forward to the
there
list
can
of
be a
such
case of
cases.
section 83, provisional attachment,
Yes,
as you have said,
yes,
or rule
yeah,
86A,
yeah. It is here also, right? Blocking of credit, yeah. For which
blocking of credit.
basically for which whatever matters we are going to the court right now, fatak se ekdam, like on the next working day or within 2 days. I think those things will be urgent matters here in the tribunal.
Section 83
But
matters will
yes,
definitely come.
yes. Any other view of the house? Any other member wants to share on this about this? Firstly, about the urgent matters and also about the permission of the appellate tribunal, because here the word used is permission of the appellate tribunal or president. So president, though we cannot say because it's only there in the principal bench. So who would be this appellate tribunal? Whether it would be the registrar and all. I think some details are given below, so we can check that.
The
So if there
appellate tribunal has been defined.
yeah, that is there. So I think no, who would be giving the permission on behalf of the appellate
Yes.
tribunal?
Yes.
So that is again the matter that is to be seen. Okay, so registrar, if you see the powers of the registrar similar to, we have some chat, so we'll just go through the chats also. One second. Acha, so Praveen ji is also sharing that what is the urgent matter. Yes, Praveen ji, so that is the main thing. Urgent ka definition kahin pe nahi hai, so that needs to be defined, I think. And so that while we say this, that urgent ka definition nahi hai, so just like the court practice, I think here also we need to demonstrate in the petition itself as to why the matter is urgent. So maybe in matters which you are preparing to file, for the appellate tribunal, for as soon as the appellate tribunal is formed, and matters like bank attachment and all these things. So in the ground itself, I think kind of in the prayer also, we need to bring out this fact. We need to actually come out with this proof or demonstrate the fact that why that matter is urgent and why it needs to be heard on priority. Like whenever we are filing this early hearing petition before the tribunals, so we give a reason that as to why this particular thing is required. Say in case of RPG, can refund be also urgent matter? I think refund rejection orders.
And see, refund rejection orders are not by the commissioner. They are generally by the assessing authority. So first the
No,
appeal
after
would
that
be
I've
for
gone to
the.
the commissioner appeals, and commissioner appeals has also rejected it. So my working capital is blocked.
I don't think, because the High Court themselves are not entertaining the refund petition SLP in Rajasthan. I am talking about Rajasthan as an urgent matter.
Right, but my working capital is getting blocked, or maybe in case of export with payment of tax, actually I'm already paying the amount, but the export without payment of tax, I've already paid for the ITC and all, but the ITC are being rejected for flimsy grounds.
In my opinion, whatever would be the rejection order for urgent, it would then be
Yes.
filed through an SLP before the High Court. Writ petition before the High Court.
Writ petition by- yes, yes.
Why it has not been treated as an urgent matter?
Acha, you are saying, oh, you'll go to the tribunal, the matter will be rejected, it's not urgent, and so then we go to the High Court.
Writ petition. The litigation within a litigation.
Right.
Sir,
So,
regarding
yes,
the
sir.
point, which we were mentioning about President, the appellate tribunal, or
Yes, sir. Yes, sir.
President,
Yes, sir. Uh-huh.
and we were giving a thought to that President would be not at the regional branches, etc.
Yes.
Since online
Delegation of power.
filings, since online filings, etc., and hearings are also contemplated,
Yes,
can
sir.
we think of a situation that where an online application is made to the president to approve this urgent hearing? He approves it online, and then he says that it has to be heard at this regional bench or particular bench of the tribunal. Can that be?
Marupji, in
Yes,
my
sir. That could be
opinion,
one of the options.
this would be, and if online function is not given on the portal, then an email can be sent.
Yes. And Gurjit sir, as you are sharing, I just had another thing in mind. Maybe the president will delegate this function to some of the vice president. So that could also be there. Because in the rules, we'll see whether president can delegate the functions of the president to the. So maybe in this particular function of considering
That
what is
would
urgent and
be-
what is not urgent,
That would
that
be
function would
another arguable
delegate it.
point when it is being said with the specific
Yes, sir.
permission of the president. So can the president delegate?
whether it can vest in the vice president or the.
Yeah.
Yeah, there also we have certain interesting things in the delegation of powers of the president. There also, because what I see this, with all due respect, how the thing has been framed is that many of the tribunal rules and the high court rules, they have been clubbed together and put it together. So that's why many
Arunji.
things which are, yes,
Arupji, Shravan Prabhuji has given a Madras High Court decision wherein they have considered a refund matters are not urgent matters.
yes, yes, yes. Madras, he's saying Madras, Bombay, AP, 3 high courts. Okay,
And this is the view at Rajasthan High Court also.
right. Yeah, I
Uh,
agree. Yeah, sure.
सर
Yeah.
सर अपने ये rules discuss करने से पहले if possible can
हाँ,
we
हाँ.
spend 2 minutes to understand the powers under which the rules are enacted so that it will help us answer many other questions. मतलब
Yeah.
section I read
111.
section 111
हाँ,
but
हाँ, हाँ.
that is a procedure for appellate tribunal.
हम्म.
उसमें ऐसा कहीं नहीं लिखा है कि as per the procedure prescribed by XYZ और मतलब उसमें तो clearly लिखा है कि appellate tribunal shall have power to regulate its own procedure. If that is the case, then all the
Right.
time limits and everything that is being prescribed is not bound by this law. क्योंकि इसमें clearly लिखा है कि it shall have power to regulate its own procedure. If that is the case, तो उस section is giving them power. Which
अर्पित
clearly
जी एक बार 111 खोलेंगे क्या आप
हाँ
डेस्क
जी।
पे हो क्या
हाँ जी हाँ जी।
So it's
ठीक।
open in my PC. Shall I share?
हाँ कीजिए ना
हाँ
एक मिनट को वो
I
करता हूँ
think it's
नहीं एक मिनट
disabled.
हाँ नहीं हो जाएगा देखिए अभी देखिए
Is it visible? Is it visible?
yeah it's visible yeah
See. So section 111 तो procedure for appellate tribunal.
नहीं एक बार इसको खोले तो एक बार just we can just go through it quickly एक बार हिमांशु जी
Yeah,
think-
it's open, right? Is it visible?
yeah it's
Screen is-
visible so the appellate tribunal shall not while disposing of any proceedings before it or any appeal before it be bound by the procedure laid down in the code of civil procedure 1908 but shall be guided by the principle of natural justice and subject to the other provisions of this act and rules made thereunder. The appellate tribunal shall have power to regulate its own procedure. Okay. So, আমি তোমায় একটু পরে ফোন করছি দাও Okay, so Himanshu, can you put it in a Word document? This first clause, subclause only.
Just a second.
हाँ
Is the Word document visible or only the
yeah, what
browser?
document is now visible?
Yeah.
No, now we have to go to the Word document. Yes. थोड़ा हाँ now it's visible. तो इसको थोड़ा बड़ा करेंगे और फिर इसको थोड़ा तोड़ते हैं इसको, जैसे the appellate tribunal, yeah. So the appellate tribunal shall not, so that is okay. Then from the next we can bring it to the next line, while disposing, yes. While disposing of any of the proceedings before it, or से फिर से काटते हैं, or an appeal, or an appeal before it, be bound by the procedure laid down in the code of civil, but को next line में, shall be guided by the principles of and को next line में आते हैं, and the rules made thereunder, yes. The appellate tribunal, yes. So this is how it is. So the appellate tribunal shall not, while disposing of any proceedings before it or an appeal before it, so they are disposing both. Appeal, though we know, but RPG, what would be the proceedings other than
The
appeal?
proceedings, yes, again, and this is one thing which has to be seen. What is meant by proceedings?
वो like anti-profiteering वाला क्या? But हाँ
Anti-profiteering, it might be an anti-profiteering case.
anti-profiteering वाले. Okay. So while disposing of any proceedings before it or an appeal before it, yeah, be bound by the procedure laid down. तो ये तो negative हो गया, मतलब RPG that they don't have to follow the CPC, Code of Civil Procedure, right? But shall be guided by the principle of natural justice. So that's why they can come with all those conditions. कि अगर in the interest of justice, we can extend the date suo motu even if the application is not made before the date of expiry and all. That's why they are also maybe coming up with all this holiday. But sorry, if there is a holiday, they can extend it, and those things. And subject to other provisions of this act. And the
Again,
rules
Arupji,
made
This
thereunder.
is important.
Arupji,
This is important.
Arupji,
Yes,
again,
so,
it is subject to the provision of this act. So
This act,
how can
yes.
by the rule 3 they can override that? And there is a specific reason that why they are not bound by the procedure laid down by the CPC. The Bombay High Court in one of its decisions has specifically said that the very purpose of Constitutional Tribunal was for expeditious disposal
Yes.
of the matters or disputes.
Yes.
So that's why they are not bound by the process of CPC, which are bound to be followed by a civil procedure code. And if we read through section 111 subsection 2, they have
Hmm.
specifically said that for those things, the tribunal would be bound by the CPC provisions.
हाँ 111(2) को भी एक बार लेके आते एक बार. But इसमें then RPG, what is the purpose of giving in the interest of natural justice? They are
Yeah,
first
they
saying
have
in the
said
interest of
that-
natural justice, then they are saying subject to the other provisions of this act and the rules.
So even if they are not bound by the provision of CPC, but they are still bound by interest of natural justice.
Yeah, so that is so always there because they are a judicial authority. But वो
For
बोलना
111(2), for these issues,
the appellate,
they are the powers of CPC, of civil court under CPC.
like summoning and enforcing the attendance of any person, examining him or not, okay. Requiring the discovery and production of documents, this is also there in the rules. Receiving evidence on affidavits, subject to provisions of section 123, 124 of the evidence, like requisitioning any public record or document or a copy of such record, issuing commissions for the examination of witness or documents, okay. Dismissing a representation for default or deciding it ex parte. Okay, so here again, they are getting that power to dismiss any matter if nobody is appearing and all. So setting aside any order of dismissal of any representation for default or any order passed by it ex parte, okay, and any other matter which may be prescribed. Okay, ये तो exception दिया है RPG that this particular
This is an
matters.
exception.
Yes.
So if we read through 111(1) and 2,
Mhm.
what it says that they are not bound by the procedure of CPC except for 111(2).
Right.
They are bound by principle of natural justice. But
Yes.
everything is subject to the provision of this act.
So again, you are saying that we've become bounded by 112.
112, because the 111 is not open
Himanshu ji,
worded.
can you go to 112 also एक बार? हाँ, उसको भी just. तो इसमें तो the admit such appeal where the tax or input tax rate or involved or the difference in.
Now take an example. Can a
Yeah.
tribunal in Rule 3 provide that we can admit an appeal beyond 30 days? Delay. Have their own
Right.
procedure. Because
No.
if they can extend the time limit saying that we are closed and you are to file on the next day, if supposedly the 30th day for condonation of delay falls on a Sunday, can it be
Right.
extended? Because 30 days time period for condonation of delay is given in 112.
So can't the tribunal argue that we are doing this in the interest of natural justice? Because we know that, maybe in certain matters,
See,
maybe manual filing may be required.
they are not a
Maybe,
constitutional authority who can alter the statute.
Sir, please read this subsection 6.
yes, the appellate tribunal may admit an appeal within 3 months after the expiry of the period referred to in subsection 1, or permit the filing of an application within 3 months after the expiry of period referred to in subsection 3, or permit the filing of a memorandum of cross-subjection within 45 days after the expiry of the period referred to in subsection, if it is satisfied that there is sufficient cause for not presenting it within that period.
So holiday को sufficient cause में cover कर सकते हैं ये.
Yeah, see, one idea of one of the tribunal members, existing sitting session members, where we had this discussion, sir's view was that this purpose of having this holiday, and this is what I was sharing, is that it's because of the litigation part. And another argument was also that maybe in the tribunal rules also, we have this situation wherein online appeals cannot be filed. So their manual appeals have to be filed. So since the office is closed, since the tribunal is closed on that holiday, that manual appeal filing will not be allowed. So it can be done only the next working day. So keeping that also in mind, this particular thing could be given in Rule 3. And as Himanshu ji has also pointed out, so Gurjit sir, what's your view on this? Or any other member? Any other one member wants to share about this subsection 6? Whether this gives the power to the tribunal to amend those dates, and also the power to suo motu extend the dates without receiving a request.
Supposedly, Aruji,
Yes.
the tribunal says that we are not working for 10 days in June.
Yes.
Now, can it be meant that power under 112(6) can be period can be extended just because tribunal is not working? I am not going on the part of natural justice. Can a body which has been formed under statute has the power to go beyond the time limit? Because high courts are regularly saying on the same thing, the office of the commissioner, if it is closed, it should also be extended.
No, but isn't it a practical problem which will prejudice the taxpayer or the
I
department,
know
whatever?
it's a practical issue or a practical problem. Again, interpretation of Rule 3.
I'm still searching
And-
for rules किस base पे बने. Like
वो मैं भी search कर रहा था actually.
ये यहाँ पे क्या लिखा है कि appeal to appellate tribunal shall be in such form, verified in such manner,
Verified
and shall be accompanied by such as may be prescribed. So
As
as
may be
may be
prescribed,
prescribed is
yes.
where the rules come.
Yeah,
Now,
so that is
all
prescribed in the
those
rules.
rules where are from where they are getting the power, like under what section are those rules prescribed? If we talk about 111, यहाँ पे कहीं prescription की कोई बात नहीं है.
No,
power
they're saying
is to
that
regulate
appellate
its own
tribunal,
procedure.
yeah,
Sir,
the
111
appellate
says
tribunal
that the tribunal has the power to regulate its own
regulate its own
procedure.
procedure.
last line. Last line of
So
subsection 1.
they are regulating
Yes, sir.
their procedure by giving powers
Yes.
and functions. And Aruta, like you were asking, requesting from. So
Yes.
my this thing is saying that it would be an interesting arguments to hear that whether by that Rule 3 of powers and functions, whether they are extending the period or whether they are communicating that how that period
How to
is to be
yes.
calculated. How that period is to be calculated. So these are two. One on one side, like Arpit sir is saying that the period gets extended. Yeah, by effectively it does get extended. But is the period getting extended, or is that being interpreted how that period is to be calculated?
I think
Even
that part.
What is within their powers, what is outside their powers?
yes.
I think ये वाला चीज बहुत clearly शायद historically established है जहाँ working days लिखा है,
हाँ.
why it talks about working days, and जहाँ working days नहीं लिखा, why it talks about calendar days. As simple as that.
Yeah, sir. Here it is not working days. It is just 3 months.
Days.
So
Yes.
yeah,
3
so
months.
यहाँ पे if section 111 is giving the power to appellate tribunal, and similar at the same point, it's mentioning subject to other provision. मतलब it is clearly bound by the provisions of this act.
Yes.
And if 112 says that may appeal to appellate tribunal against such order within 3 months from the date, it's very clear. It does not
No.
require any rule or interpretation.
So Himanshu ji, one thing is there is that the clarity is being brought that how to calculate that from that date wala issue. Jo Gurjit sir is saying, and I'm also in support of his view only, that this how to calculate this within 3 months from the date on which the order sought to be appealed against is communicated to the person. So basically through Rule 3, they're just clarifying ki, when you are calculating, you have to calculate it this way. Harpreet ji.
Arupji, let's take an example that the
हाँ,
term within has been defined by Supreme Court, that this is the meaning of within.
right.
Can a statute, by way of a definition, alter that meaning of within?
No, but this is in line with this thing, no? General Clauses Act. जो Rule 3 में है, that is in line with
No,
the
again, there's general applicability of it.
Arpit sir,
Yes.
if I've understood your statement correctly, you're saying that if Supreme Court has decided and given a definition of within, what is within, can a statute define within? Can the statute not? Can any statute not define that? Within would have been defined by Supreme Court in context of some act, something, some which is within, maybe
Hello?
that particular act also, or any other statute
Kanya
also.
Latson.
Even after Supreme Court's decision, they can
Finally,
say that was the
Kenya
Supreme
Latson.
Court's decision at the in the what statute was stating at that point of time. This statute can be amended later on by giving a new definition for within. If I've understood your statement, please.
Yes, Gurjit, but then it has been given, firstly, a term within is normally defined. So can a statute give a meaning to it which is not within the normal ambit of that word? First thing is this, and second, this is
Yeah, yeah.
coming through the rules. This is coming through the rules.
No,
It is not coming through the
Arpit ji, if
statute.
Arpit ji,
Again,
if you
sir,
look at
I'll
it this
just
way,
bringing it back to the rails. One thing
that
is
within is not defined in the
yes.
Act. So for within, we had to refer to General Clauses Act. So now the rules are given. Yeah, Gurjit sir. Sorry.
I was saying bringing the discussions back on the rails, attempting to do that. So
Yes.
the rule 3 of powers and functions is not only confined to the admission of an appeal.
Right.
It
It's beyond
relates
that.
to all it's beyond that. It is for all the any kind of act which is being done or whatever action is to be done, etc. There is something. So this would again be another thing, that whether it includes the admission of the appeal also, and can it go beyond. So our entire discussions are being centered on this, that does it apply to that also when it applies to all the actions. So that will be another point of
Yes.
argument
Yes.
which can be stated there. Does it include this or does it mention all other things if we go by Arpit sir's view?
Yeah, Arpit ji, that is even
Mhm.
that is what I also wanted to highlight, because it is going beyond only the filing of the appeal. It's for all actions,
Yes,
as
yes,
I've shared.
definitely. Definitely. That's what I was saying,
So
that any
उसमें
other act,
उसमें
time
उस
limit under
yeah.
any other act is one.
So any other act में Rule 3 will become legitimate, because if say I have a evidence to be submitted on the 9th of June, and the 9th of June falls to be a holiday as for the tribunal, like I'll just give a recent example, what has practically happened with us. Income Tax Appellate Tribunal, we had a matter on 14th April. We got in the cause list, it was there, Income Tax Appellate was supposed to operate. But suddenly on 12th April, the government order comes and it is told that 14th of April is a holiday for the ITAT. So in this case, I am beyond all means to attend the hearing. So I am beyond that means to submit that particular document also. Even if it is not a hearing, if it is a miscase, matter. So if I was supposed to submit the evidence or submit the affidavit, or somebody was summoned to the assessing officer was summoned to the tribunal. So in all these cases, the action cannot be carried out because of the holiday, and that's why maybe this Rule 3 will be a beneficial kind of feature for the taxpayers as well as respond, and that's why it is being brought in, I think.
And
Let
so
us see,
this brings
Arup.
us to the point which Anupama ma'am has mentioned in the chat, that is it applicable only for the manual submissions, etc. That is a point she mentioned earlier, no, when we started discussion.
Yes. Annapurna ma'am said yes. No, but I don't think it is only for manual filing, because one of the important
Yeah, this
purposes is
is
manual
another point
filing.
of discussion here, that
Yes,
whether it
yes.
is only for manual
Only
or
for
for
manual.
everything.
But I think since the word
सर
manual has not been used.
एक सिंपल सा एक केस हाइपोथेटिकल एकदम बेसिक लैंग्वेज में कि मैंने अपील फाइल किया और उसमें 3 मंथ्स जो एंड हो रहा था वो हॉलीडे था, तो मैंने 3 मंथ्स 1 डे पे मैंने फाइल किया.
ओके.
डिपार्टमेंट बोलेगा सेक्शन 112 में 3 मंथ्स लिखा है. मैं क्या बोलूंगा? वेदर आई विल से कि भाई रूल में लिखा है कि सो डिपार्टमेंट का स्टैंड ये है कि सेक्शन में लिखा है और मैं बोलूंगा रूल में लिखा है.
No, I think तब क्या होगा, then the tribunal will come into play and say that we have clarified these two things within वाला चीज कि कब से होगा, and second is we have already clarified that it's a holiday.
Bound by the provisions of this act. It clearly mentions is subject to the provisions of this act.
Right.
Tribunal cannot make its own rule. It's not a government. यहाँ पे clearly लिखा है subject to the provision of this
Rule.
act, और डिपार्टमेंट बोलेगा provision of the act says 3 months.
So
It would be the tribunal in your case who would have admitted the appeal. What? So it will be the registrar or the tribunal who will be saying that we are saying that the period of this within 3 months is being calculated in this manner, and that is why we have admitted the appeal.
Yes.
That would be the view of the tribunal.
Somewhere down the line,
The other person
department
would be arguing, the government would be arguing that why it has been admitted, it should be rejected. And it will
so
be
they
from
would be
their side
challenging
that
the rule itself.
They'll be challenging the rule itself.
So with this,
So anyway,
Avruji, it's 10 p.m.
Yeah, so that's what I said. So finally, it's so surprising to see, even though rule में हम लोग discuss कर रहे हैं, उसमें 1 घंटा निकल गया. That is the beauty of SMS. So thank you, and I think it's really in depth because I have at least taken out some note points. So I think that is to help in the refining the entire discussion going forward wherever we are having sessions on tribunal. So that is then I've shared. Next week we are having the critical analysis of the GIDC judgment by the Honorable Gujarat High Court. So one of the counsels who's argued with this matter, he will be present here to do the case analysis for us. We were planning it for today, but somehow it didn't happen. So then we had planned another thing for panel discussion, that also did not happen. So anyway, so next week is that discussion. The week after that, we have a BCS RRC, but still we'll have a session on the pointers of tribunal going forward. And on the 21st of June, we are going to have a panel discussion wherein chartered accountants and advocates who are regularly appearing before the tribunal will have a panel with kind of fireside chat, like quick queries and answers from the panelists. So looking forward to meeting each one of you on the next Saturday and the coming Saturdays also. So thank you very much. Please do volunteer to be a speaker. You can send a message to any 4 of us. So we'll be happy to have you as a speaker here. And before we part off, thanks to Arpit ji, Himanshu ji, Gurjit sir, Annapurna ma'am, Somaya ma'am, Mahesh ji, everybody who has
And yourself also. And yourself also.
Okay. So thanks for the participation, and we'll go to Unniji for I think Unniji is here. Unniji, will it be possible for you to speak? I think he was traveling. Okay. So thank you very much, and looking forward to the next week. In case you have any specific question, the speaker has requested. In case you have any specific question relating to the GIDC judgment, whether applicability of the GST on assignment of the lease, so you can also post it, share it with us, so we can also share it with the speaker beforehand, so that he'll become prepared with the questions also. Thank you so much, and have a wonderful day ahead. Thank you very much.
Thank you, sir. Thank you, sir.
Thank you. Thank you, sir.
Thank you so much.